Hello, this is Barb Teachblade Reynolds. I hope everybody's having a great weekend. I'm taking the time to record this session because a friend of mine contacted me by email, which is teachblade@gmail.com, by the way. And she is a registered nurse and a paralegal. So that's really impressive. She's just getting started and read my book, this book here, by the way, and had a few questions. And I thought rather than to contact her directly and make some comments about some very important questions that she had, that I would videotape it for the benefit of anybody legal who was interested in appreciating what she should do at this juncture. She was reading the chapter 3, by the way, of the book, called How to Think Like a Lawyer. Now, let me preempt this discussion to say one thing, quick thing. This book entitled What You Didn't Learn in Paralegal School, Law Office Practice Skill Sets, is not, and I repeat, is not an indictment of anybody or anything in the profession. Quite the contrary, it's what it is. And it's simply a matter of moving past that and getting to the very essence of those particulars that lawyers must see now in their law firms in order to effect a continuum and preservation of the system of American jurisprudence in American law firms and as they affect the American paralegal profession. So with that said, um, my friend had some questions about how should she think about the law, this body, this enormous body of work called the law, and how to interpret it and apply it in these real client cases that she will come across, and she didn't quite know how to handle that. Good question. So we're going to address the issue today that's in the book, by the way, of how to think like a lawyer. And we're going to talk about the third component of how to think like a lawyer, which is deductive reasoning. Okay, suffice it to say, there's three ways and three ways only that lawyers think. They do not think 100 ways. If you remember the mnemonic LAD, oh, he's such a nice young lad. Linear reasoning, analogical reasoning, and deductive reasoning. Linear reasoning, the root word of linear is line, as in timeline. So with linear reasoning, you're analyzing a series of factual events that occurred or did not occur over an extended period of time. Analogical reasoning is the analysis of a base case with a review of the base case and a review of your client's factual case with that base case to determine the similarities and to determine the dissimilarities in the base case and your client's facts of the case, to see whether or not that base case is a means of supporting authority in a memorandum of points and authorities that supports a particular motion that you have in court. Absolutely critical that you appreciate analogical reasoning, but we're not going to deal with analogical reasoning now, and we're not going to deal with linear reasoning now. We're going to deal with deductive reasoning, because deductive reasoning deals with rules of law, statutes, administrative regulations, city ordinances. What does the city ordinance have to say about how many dogs I can have in my backyard without constituting a kennel? If it's a kennel, then I have to pay city taxes. Those types of issues. How many days does a landlord have to return a deposit of a former tenant? 21 days, and if they don't, then you can go ahead and sue in small claims court. The codes tell you that. The codes define the rights and obligations of the parties toward one another. That's what the codes do. That's where the fight and the engagement, the rules of engagement, so to speak, that's where they begin. They begin with an analysis. They begin with a legal research into what are the facts, what are the rules of engagement that define this fight in court. What are the rights and obligations of the parties? So before you can even get to a case that supports an argument in court, before you think about a timeline, you've got to figure out what has happened. What are the rules that govern the rights and obligations of the parties relative to what has happened in this case? Now, my friend, being a legal nurse consultant, will read and review and analyze a lot of medical records. She's a registered nurse. She's done that for decades. She's very, very good at that. But overlay that discipline with the law, she's got to be as much on top of that game as she is as a registered nurse. That's where I come in. That's where the book comes in, to help her to arrive at the conclusions that lawyers have already arrived at. They want her to arrive at the same conclusions, and I'm going to show her how to do that and show you in the process as well. Now, she said to me, and it was so cute, she said, "Oh my God, you mean I've got to go back to school?" I said, "Honey, I hate to tell you this, but you will never leave school. If you intend to be among the major players in this profession, you will always stay on top of your game. You will stay on top of your game 44 years later, because that is the nature of the beast. You cannot rest on your laurels. Don't even think the thought. Banish the thought. You will always be reading and reviewing and taking continuing legal education classes, just like lawyers. If you're going to be a lawyer's right hand, I guess you better be on top of your game just as he or she is on top of their game." That's the political and legal reality of things. So is she going back to school, to an actual building? No. She doesn't have to do that. But what she's got to understand and appreciate is that lawyers think a certain way. She's got to follow suit just like they do in order to be that lawyer's right arm. Her profession and what she seeks to do, which is to testify as an expert in court. Okay. Well, to do that, there are certain rules of the game that will govern what she can say, how she is authenticated as an expert witness, as opposed to a lay witness, which cannot render opinion, can only render facts within their own personal knowledge, but an expert can render opinion. That is what my friend will be doing on behalf of the attorney, on behalf of the attorney's client, rendering an opinion as to what happened in that auto accident case, what the medical records say, how they are to be interpreted based upon her knowledge as a registered nurse, as well as her knowledge as a practicing paralegal. So with that in mind, I told her, you're governed by codes, you're governed by statutes that you have to understand how to read and interpret, and enters the concept of deductive reasoning. She has to appreciate that before she goes into court, there are certain rules of the Business and Professions Code, which is a part of the California Code, that will be operative. There are local rules of court that will be operative, that will tell her what their particular qualifications are in that judicial district. For instance, Kern County, or Los Angeles County, or San Diego County, or Northern California, Eastern District. She's going to have to satisfy those requirements, which means she's going to have to read and interpret the rules of law governing her ability to qualify as an expert. She's got to know that. She's got to be able to parrot that to the attorney. She's got to know that code when she goes into that court. If she's asked any question about the rules of law that govern her ability to be there, she needs to be able to speak to those issues. Also, knowing a part of the case, the inner workings of the case. What happened? What are the rules that govern the auto accident? Well, the California Civil Code, the California Code of Civil Procedure, which is how you get your paperwork through the court. Certain business and professions code may apply. Certain parts or provisions of the vehicle code may apply. After all, it was two vehicles that were involved in the accident. Now, in reading the local rules of court, in reading the California Business Code, in reading the California Code of Civil Procedure, the California Civil Code, there are elements that make up those rules of law. It's sort of like, I've compared it for all these years of teaching to a pie. And you slice up a pie and you analyze and digest each slice of the pie. And once you've analyzed each slice of the pie, put the pie back together again. And now you have a pretty good comprehension as to what that rule of law says. Let's take for an example, my friend involved, she knows the case involves an auto accident. Well, anytime a case involves an auto accident, usually the parties are simply negligent. They weren't looking, they were turning the radio in the car, they were dealing with and under the influence of children. Mommy had to look back for a second and here comes an accident. It's not an intentional event. It's not an intentional tort. So it's not a tort. It's an accidental tort, which is called negligence. So anytime my friend reads a case that involves an automobile accident, she immediately thinks of the tort of negligence, which is an accidental injury to persons and or property. And they're so common. I mean, you can bump somebody's car and not even realize it, and it's negligence. But the question becomes, is it actionable negligence? Do you have any damages that makes it an actionable cause of action for negligence in a court of law? And we're going to analyze that. Most of the cases my friend would address in the law office she's working with would involve clients that were involved in actual auto accidents where there were real damages. So in analyzing that case, in reviewing the facts of that case, she's got to have a frame of reference as to how she's going to analyze what she's reading. And she's going to analyze what she's reading in the context of a negligence cause of action. A negligence cause of action is a rule of law. The dog bite, the rules that govern a dog bite, that's a rule of law. The rules of law that govern where you can ride your motorbike on a freeway, those are rules of law that govern your rights and obligations. So the cause of action of negligence is one of those rules of law that has to be analyzed in the context of deductive reasoning. And deductive reasoning, it's in the book, okay? It's in the book. Deductive reasoning has three components. It's like a paralegal is everything minus three, so kind of remember the number three. It has three components, okay, of deductive reasoning. One is the major premise, and you can write this down. I hope I'm not talking too fast. The first is the major premise, okay, M-A-J-O-R, major premise. The second is the minor premise, and the third is the conclusion. If you read and interpret a rule of law within the context of a major premise, a minor premise, and a conclusion, you cannot reach the wrong conclusion. You will reach the conclusion of that lawyer every single time, and he or she will think you are absolutely borderline genius, okay? Major premise, minor premise, and conclusion. The major premise is the rule of law, the rules of the game of negligence. The minor premise are the facts of your client's case. And you take the facts of your client's case and try to plug those facts into each element of negligence, which is your major premise. And if you fit each fact of the client's case into each element of negligence, guess what?